Welcome to the video. In just a few slides, we'll break down the crime of robbery, its definition, legal elements, and important cases to help with your revision and understanding. Robbery is among the most serious property offences in English criminal law because it combines two elements, theft and violence. Unlike theft, which involves dishonestly taking property, robbery adds the element of force or threat. As a result, robbery is not only about the loss of property, but also about the harm, fear, and intimidation suffered by victims. Because of its seriousness, robbery is an indictable-only offence, which means it can only be tried in the Crown Court. This makes it distinct from less serious property crimes, which may be dealt with in lower courts. The law treats robbery as an offence against both property rights and personal safety, acknowledging the potential harm and fear caused to victims. Its status within the criminal justice system reflects the balance it strikes between property crime and violent crime, demanding robust legal responses. The maximum sentence for robbery is life imprisonment under Section 8 of the Theft Act 1968. This demonstrates how seriously the law views the combination of dishonesty and violence. Robbery is not just an offence against property, but one against personal security. In the rest of this presentation, we'll move from the legal definition to the actus reus and mens rea, then through key case law, sentencing guidelines, and finally, a critical evaluation of robbery as an offence. By the end, you'll have a clear and structured understanding of robbery within English law. Robbery is defined under Section 8 of the Theft Act 1968. The statutory definition makes it clear that robbery is essentially theft plus force. A defendant must commit theft, but also use force or threat of force immediately before or at the time, and for the purpose of stealing. This definition highlights robbery's hybrid character. It is both a property crime and a violent crime. The seriousness of robbery stems from this combination, which makes it distinct from theft alone. The actus reus, or physical element, of robbery consists of theft plus the application or threat of force. First, there must be a completed theft, meaning the elements of appropriation, property, belonging to another, dishonesty, and intent to permanently deprive are satisfied. Second, the defendant must use or threaten force on any person. Case law has established that even minimal force can be sufficient, provided it is connected to the theft. Finally, the timing of the force matters. It must take place immediately before or at the time of stealing, and it must be done in order to steal. These requirements distinguish robbery from simple theft or assault. The mens rea of robbery builds directly on that of theft. First, the defendant must act dishonestly. This is judged by the objective standard clarified in Ivy v. Genting, where the focus is on whether ordinary, reasonable people would consider the conduct dishonest. Second, there must be an intention to permanently deprive the victim of the property. Without this, there is no theft, and thus no robbery. Finally, the defendant must either intend to use force or at least be reckless about the possibility of force being used. The key is that the force is connected with the theft. It must be applied in order to steal. Case law has clarified the meaning of force in robbery. In R.V. Dawson and James, 1976, the Court of Appeal held that even a small nudge that unbalanced the victim was sufficient to constitute force for robbery. This highlights that the level of force required is minimal. Similarly, in R.V. Clouden, 1987, the defendant wrenched a shopping basket from the victim's hand. The court confirmed that this was force on a person, even though the direct action was against property. Both cases demonstrate that what counts as force is very broad. Importantly, the jury has the final say in deciding whether the actions amount to robbery in the circumstances. Timing plays a crucial role in determining robbery. In R.V. Hale, 1979, two defendants took jewellery and then tied up the victim after the theft. the Court of Appeal ruled that appropriation is a continuing act, so the force used afterwards still counted as robbery. This principle was reinforced in R.V. Lockley, 1995, where the defendant used force on a shopkeeper while trying to escape with stolen beer. The court again held that force during escape falls within robbery's definition. Together, these cases highlight that theft can be seen as an ongoing act, meaning that the use of force during or even after the initial appropriation may still satisfy the elements of robbery. Two further cases highlight important distinctions in robbery law. In Corcoran v. of Anderton, 1980, the defendants knocked a woman down and grabbed her handbag. They dropped it in the struggle, but were still guilty of robbery because the theft was considered complete at the moment of appropriation. By contrast, in R.V. Robinson, 1977, the defendant believed he was owed money and used force to take it. The court ruled this was not robbery because his honest belief in a legal right meant the dishonesty element of theft was absent. These cases illustrate that robbery can be established even if property is not retained, but also that an honest belief can prevent liability altogether. Thank you for watching this presentation. If you found the content useful, make sure to like the video and subscribe to the channel for more A-level law presentations and study guides. Sharing the video with classmates can also help others who are preparing for exams. Finally, don't forget to turn on notifications so you never miss future uploads on criminal law and beyond. Your support helps keep this content going, and I appreciate every one of you tuning in.